Шановні колеги, прошу спікерів зайняти свої місця. Ми розпочинаємо.
Dear colleagues, please take your seats. We will start the third panel about advanced policies of responding to CRSV. Thank you.
Шановні колеги, дозвольте висловити певне своє бачення з приводу нашої третьої.
Allow me to say a few words as regards our third panel.
Переконання, що це панель взагалі-то найважливіша панель.
I believe that this one is the most important panel, because when we speak about the human rights, this basically is the main indicator of the workability of a law enforcement system. This is about the main principle of the organization of any state, human rights. And obviously, we should speak about the mechanisms which are put in place to make this happen. I'm very glad to introduce to you the panelists. I know all of them personally, and this is only natural because these people are not just the good experts in the situation and the subject matter in Ukraine, but they are also strong personalities, activists, and people who are advancing these issues in their field of activity in implementing the key principles that we've mentioned now, the human rights and the rights of survivors. I will give the floor to all the panelists according to the agenda, but I'd like to ask you to speak briefly about the implementation of instruments of recording and documentation of cases of those who suffered from CRSV. The thing is that the terminology in this process and in the formulation of messages which are being used in this field largely determine the efficiency of this communication. The organization of legal communication during the war is a most
небезпечний він з точки зору результату, до яких можуть привести правові комунікації, реалізацію тих чи інших подій. Ну, як приклад, хотів би навести, цей приклад знайомий всім, ми всі це пройшли і, відповідно, зможемо зрозуміти, як важливе обрання правової мови, термінології в реалізацію тієї іншої соціально-правової комунікації. Отже, національний телемарафон. Це з перших днів війни головна мета єдиного інформаційного продукту, який почав виходити, це, звичайно, об'єднання нашої нації в умовах війни. І обираються, в дуже складних умовах, обираються певні терміни, певні тези-слогани, які починають працювати і просуватися основними медійними стейкхолдерами нашого телемарафону. Шановні колеги, згадаємо, будь ласка, 2-3 тижні, 2-3 тижні, 2-3 тижні. Далі у нас комунікація пішла відносно того, що російські військові воюють за методичками Другої світової війни, проблеми російської армії, далі контрнаступ, розгромний контрнаступ, останні меседжі «До літа ми будемо в Криму». Шановні колеги, не з точки зору зради, з точки зору реагування і бачення цих комунікацій, без жодних якихось власних оцінок, просто звертаємось до соціологічного дослідження, яке з 1 по 13 жовтня провів Київський міжнародний інститут соціології щодо дослідження телемарафону. У порівнянні з 2022 роком аудиторія телемарафону зменшилась в 3 рази. І не в тому величезна проблема, що зменшився контент людей, які дивились телемарафон. За висновками цього ж інституту, основний глядач перейшов в телеграм-канал, і це теж в телеграм-канал, і це теж певна небезпека, тому що російський контент там присутній. Так от, в цілому результат обраної комунікації знизив рівень довіри до влади в цілому, починаючи з Офісу президента, закінчуючи Верховної Ради. Тобто з 73 до 20% рівень довіри на сьогоднішній день до Верховної Ради. Так само знизилось з 70 практично до 60%, до 74 до 39% до уряду. Отже, одним словом, шановні колеги, до чого це веду? Обрання
television marathon. What I'm trying to say is that the use of terminology and slogans of communication are really key. But not everything is that bad. There are some unique and very good examples of communication, especially in our field that we're talking about. Let's recall the communication of the Vice Prime Minister for European and Euro-Atlantic integration, the Office of Ombudsman, and the Office for the Affairs of Veterans. The content of the messages was very simple. We have to provide assistance here and now without waiting till the war ends. The right messages were selected, and a very workable system of supporting the survivors was put in place. We can mention very efficient work of our law enforcement bodies as well. And the efforts of our legislators. Please show slide number 2, which will show us the unified, effective system of our legislation, which defines the status of the survivors or affected individuals, and all the instruments of providing them with assistance, help, compensations, and reparations. This is the result of a comprehensive work which was going on in parallel line with what the NGOs and civic society were doing. And it is the work of our project, and I'm gratified to say this, of UA expert work, in particular of Snezhana Kush, made it possible to get those draft laws to the Verkhovna Rada Parliament. Since time is tight, I will skip talking about the urgency of the adoption of some concepts to respond to CRSV, but I'd like to show you slide number 4, please. Slide number 4 shows the main tasks which we are dealing with and which we need for the effective communication to respond to CRSV. First of all, this is documenting, recording, and investigation, efficient provision of comprehensive advocacy and defense services, and the implementation of comprehensive strategies in order to create comprehensive campaigns during the war and during the after the war recovery. So first of all, I'm focusing on recording and documenting, which in my opinion is an urgent area of work, because we all understand what this will largely determine the final result of our efforts. Slide number 5 is about communications for response to CRSV cases. This envisions cooperation with survivors and the provision of rehabilitation services. Social violence is a tactics used by the enemy. All the perpetrators should be brought to just and fair court trial. Ukraine has a unique experience, and the assistance provided to survivors is based on international standards, with all the harm to be compensated in full. Together with our international partners, we are ready to build up our potential to provide assistance for all the individuals affected. If we formulate all those tasks, then for us, in order to finally enhance the communication, we have to formulate what is necessary for any kind of communication. This is a very comprehensive, very painstaking and fundamental work about selecting the basic fundamental paradigms for this communication. Therefore, we define the principles of legal communications. I'm not going to go into details of that. It's obviously people should be put at the center of this, and justice is the form which should be served in any circumstances. Transparency, integrity, confidentiality, professionalism, and scientific foundation and research foundation. This is something what we do. When we record the evidence, when we document the evidence, cases of CRSV, if the survivor wants to terminate this communication, it should be terminated. Any survivor, any affected individual is unique, and we have to respect that. Obviously, there should be and there should be individual approach. It might appear very simple when we speak about that, but then when we go into detail, more additional questions arise. And the primary reason for that is something which we've mentioned time and time again. This is the adherence to the legal terminology which we are supposed to use in our communications on CRSV. The main principle is about the term victim and the term survivor. I'd like to come back to the idea which was promoted by the head of our organization. He keeps raising this issue time and time again. In our opinion, we can encounter serious problems if we fail to provide clarity, and if we keep this dualism in the notions of survivors versus victims. I can refer to Alexei Gumin's experience. He is head of the department of Lviv Polytechnics from the Faculty of Philosophy and Law, they've been dealing with these notions for a long time, and their position is clear-cut. A victim is a potential survivor, and not every survivor is a victim, because a victim by definition is much broader a notion than the notion of survivor and affected individual. We've addressed the system of criminal judiciary proceedings of the US, and in their terminology, there's no term poterpili. There's only the term victim, poterpili, victim, жертва, or injured person or injured party. So it's only in a judicial context that we will be able to have the notion of a survival. Why do we resort to the legal school?
Юридичної термінології.
Because selection of this legal terminology, and in our opinion, well substantiated, the change of this will provide for compensation reparation. Let's remember all the existing international mechanism: compensation for victims of Holocaust, victims of the system for slavery created in the Second World War. More than 1 million people eligible, and they received compensation, among them many Ukrainians. And in the Balkan Wars, victims provided with financial assistance, and they call them also sufferers from CRSV. And I would like to apply to Madam Rusheti, head of the Center of Victims of Torture, for Victims of Torture, to opt for this term, because we are trying to fathom the experience, to appreciate it, to comprehend it. And we have signed this memorandum between EU experts and the said center, and we're following the pattern of reparations those who suffered from CRSV during the Balkan War. So to get this assistance, all the sufferers should gain the status of victim of war, and this category encompasses not just people who suffered from CRSV, and when they get this status, they can be eligible for the assistance. Dear colleagues, remind yourselves of the system of legislative initiatives that we have for the Parliament. There are three basic statutes regulating that. We have lived through all of them. There's no notion of victim. And there are injured persons, sufferers, but in all the amendments added to this by the legislature, and in the documents we refer to, for the sake of our partnership, draft resolution on partial agreement on the register of damage done by the Russian aggression. Here we have the notion of victim, but not in the laws. So these actually voluntary and careful use of this. I would like Jean to refer that we discussed that with Valentina in the documents that will be discussed by our speakers also. There's this notion of victim. Dear colleagues, the most important thing in our opinion is to get reparations and compensations. When we discuss creation of this special fund, we mention that we have international donors contributions at more than 90%. If we have different concepts and different interpretations that can lead to complications, and our vision, our position based on, sorry for trespassing on my time unduly, but that leads us to documenting crimes and the status of a person suffering from CSV. We use the legal term of victim. This is clear, and this is the most important thing to get result for our future international activities. Now, speaking of the process of advocacy for the sufferers or injured persons, of course, we can use the tolerant, politically correct, and this is our vision, this is our proposal. And while I am passing the floor to our next speaker, I would like to shortly, for a short while, for a glimpse, to present our last slide that we prepared for us to be able to present the slogans that we use in providing assistance to our sufferers. Well, and if you have any issues with that, I would like to turn the floor to Jane Oliva. She's a prominent person indeed, because promotion of in the international legal field, practical assistance to the sufferers and practical implementation of the activities abroad. I remember Colonel Kemp's presentation. He was referring to you and your fruitful cooperation. I would like to go on the issues of reparation and possibly visibility of choice of specific terminology. Hello, I would like to greet all of you. With my body, I'm not voluntary, but I saved my family and my household. During the war, we regarded ourselves as warriors and defenders, because now we are victims of the state, because we need support. I need compensation for my spirit. If I have no money to treat myself, my child that was given to me by a rapist soldier, I have no life. I just have to survive. I have to be exempt for payment for medical services and get the pension, not just because I lost my husband to this war, but also for what the enemy did to me. We have all sacrificed things for the country. I sacrificed my body, and that wasn't voluntary, and that does not let me sleep at night. So this is not verbatim, but this is translated from different languages. Women who fell victims in Japan, Korea, Kosovo, and Germany from the Red Army. Victims of war. And some of them stepped forward after 30 to 40 to 50 years, 30 to 40 to 50 years later. It's our duty now to learn from our mistakes and examples of other countries, not to become mistakes and bad example for the subsequent countries to learn when they encounter sexual violence and at war, because this is now weaponized by one of the parties, and this is the case of history. This is what is happening in Israel and Palestine, and this is what is happening in our country right now. Well, I think that learning from mistakes, lessons learned, should also entail some change in the legislation. Some things have to be done better and faster. Let's hope that we will give enough attention to that, because for implementation of certain justice for Ukrainians, We cannot proceed unless we do that, and we have to disseminate information in other languages. So let's come back to the first example. Mistakes or case studies coming from other countries. Or last month, on how many occasions we would see on the news, on the front pages, victims from Israel and Palestine. And how many Ukrainians over 2 years recently speaking up, Ukrainians speaking up and discussing the situation in our country. I do not think we win because we have to study English. This is not just responsibility for the mass media and our governmental bodies and their representatives. This is also for us here. Students, I'm still a student. It's a lifelong exercise with me, I suppose, because international response, international reaction will actually stay the course. And this is all legal, this is all political, and should be all accessible. The financial support I will discuss later. I represent not just the charitable organization that is concerned with assistance to children, and that includes psychological rehabilitation, but I also represent a legal international company that is called Payback for Ukraine. This is Richard Kemp, and we will Richard Kemp, Colonel Richard Kemp was talking about orders given. We are talking about essential reparations for the Ukrainian citizens, and this is our mission. So on the team, we have more than 1,000 lawyers and law firms in different countries of the world, US, UK, Canada, and EU countries. And in fact, these are international volunteers who are helping Ukraine in the in our legal affairs abroad. And they advise us on the best and fastest launch of specific process. The head of this initiative, a person who has been involved for 30 years in advocacy for human rights, specifically reparation, 2 cases, one against Hamas, 2 cases, one against IRA, and he represents victims of Rohingya genocide. He represents women in Sudan, victims of sexual violence, and he's now dealing with a big project for Ukraine, where we are talking not just about victims of sexual violence, but there are more to it, and we are very grateful. Jason McHugh, who has visited Ukraine on numerous occasions, and there's more to come. There's more to be expected, and on one of his next visits, I think he'll be delighted to talk to students and pay attention to specific areas. Now about Payback for Ukraine and what they do. This is High Court in London and against so-called Wagner private military company and Yevgeny Prigozhin person. We are directly involved in recognizing so-called Wagner as a terrorist organization, and the Russian Federation put Jason Matthew Turi, who are in charge of payback program, the sanction list of the Russian Federation. That is a token of recognition, the best compliment we can expect. This is about efficiency, and this is about motivation to proceed. And I would like to also shortly discuss the cases that I can discuss and that we are still involved in addition to Wagner, these cases against propaganda mongers against Iran for kamikaze drones, for abduction of Ukrainian children, tortures of civilians and military in Ukraine, sexual violence against military and civilian citizens of Ukraine. And let me say that we are working with the Ministry of Digital Transformation in this Wagner case, and so we have potentially more than 180,000 sufferers. To speed up this process, we would like to create this form, a DIA platform for people to be engaged as soon as possible. But it's not just for DPs, like in the UK, 180,000 people, but Victim for Victim program we created, which provides for the opportunity for Ukrainians living in Ukraine and falling under this category to also to claim such reparations. And when I talk about essential reparations, I mean not $200 to $500 in equivalent. And with the successful cases abroad, we have compensations for victims of Hamas up to $10 million, and this very much depends on the situation. And in Ukraine has good chances for essential reparations for the victims of sexual violence. And if we call a spade, as somebody invited us to, and the society should have trust in the system, in the government, and and civil society, civil society organizations. If it is necessary, this information should be presented. Everyone should accept this responsibility, and the changes should present a respect and very diplomatic interviews with the psychologists, and nobody triggers any kind of anxiety in any kind of person, because the Ukrainian media and other media, we have this, but this influences the result and our work and our performance, and this influences decision-making for another victim and their decision to testify, not to testify. Without trust, we cannot have testimony. Without testimony, we cannot have a case in court. And this is very important because we do not want to wait for 30, 40, 50 years for some courageous person to step forward and take decision. And this should be done today. For that, they should know why they're doing that, to what end. And we have to accept this responsibility. And after this event, we can tell our friends and relatives that there are 12 centers in Ukraine to help the rescued people, rapeseed flower, and this is something that some bloggers do not want to to some people have to the duty to talk about it, and then we can get a yes in response to your approach to the international opinion leaders who can also change the situation. And in that case, we have this opportunity to take away the Russian assets and give that to the victims. And that is for payback for Ukraine. That is our mission. And today, I would like your friends and colleagues to be informed. Tomorrow, you can tell them and your students lecturing, make a post on Instagram and Telegram, or whatever you use. And this is very also important if just one person tomorrow dares to testify. We will be able to think that this day has not been in vain. Thank you, Jane Alieva, for the assistance, Payback for Ukraine. Thank you for your activity, public activity, for your advocacy, for lobbyism, for compensation for the victims suffering from the war. Thank you for sponsoring such thanks to your expert, UAE experts, Kyiv, Taras Shevchenko University. We recently had events there. Olga is online with us. Is she on the call? Yes, I'm here. We are very grateful to you. We can hear you well, loud and clear. Thank you very much for not being with you from the very beginning, offline, which would be very good and instructive. So if you repeat some ideas that you've already heard, my name is Olga Poedinok. So I would like to apologize for repeating some points that you've already heard about. Let's me in preliminary fashion discuss the very title of this panel: progressive practices of combating CSV. And as an international lawyer, I seek and I'm in search of progressive practices. I'd like to borrow from the international law for the sake of our Ukrainian context, and for us not just to have such practices in place, but also to be able to improve them, develop them through our experience. So we have the National Forum adjudicating cases of sexual violence and convicting the perpetrators. I tried to look into the status of victim and what we can borrow. The distance covered by international criminal law is spectacular, especially for the status of victims. If we look into the Nuremberg tribunal practice, there we had just 14 victims testifying. 27, that was in Tokyo, but then gradually but steadily the case law would develop, and now the victims' participation as a principle and friendly treatment of victims, care for victims, these principles are now guiding international criminal procedural law. And if we look into the Rome Statute, there we can see the three components, three principles underlying the status of victim and supporting it in criminal procedure. This is assistance, participation, protection, and the principle according to which victims are eligible for reparations. Well, this is not that simple. It's not that simple because the case law, international criminal tribunals, is full of the cases where victims would be used or other abused as witnesses, a source of information, as informants, and for some victims, in certain situations, prosecutors would sacrifice their interest for some more important prosecution. And we had this discussion on these international relations, and I would give that example, and there were quite a few such examples when people would plead guilty for certain crimes and then be acquitted of the sexual crimes. That was the arrangement, and that was the bargain, and at the expense of the victims. And we have other problems in international criminal procedure when one of the teams of lawyers would represent a great number of victims, hundreds and thousands of people, and how to strike this balance and individual interests of specific victims. And sometimes they're overactive in the eyes of prosecutors, and they are regarded as a nuisance. And this is not just true for the international criminal procedure, criminal trials. Let me give you some cases of sexual violence. I acted as tutor for help course for law enforcement on domestic violence and violence against women. We had a poll among our law enforcement officers participating in that course, asking them what would prevent them from being effective in this category of cases. The answer was behavior of the victim, their representatives, and Mom Circle. That was not the last position mentioned. There. So this is a challenge in its own right, and in my book, this also presents another thing mentioned by our distinguished moderator at the beginning of this third panel. This is about the perhaps I'm misunderstood, but that it is not fair to have not effective to have uniform recommendations. I can see that our prosecutors, our law enforcement officers, and they are not just dealing with something that is necessary or obligatory. We are talking about victims with traumatic experience. So every victim has some traumatic experience. There's nothing bad in uniform guidelines. Moreover, I think that it is necessary to take into account the approaches, the principles, the techniques which we have in adjacent spheres, bordering spheres, and we can use them. For example, with the Council of Europe, this help course for violence, domestic violence or violence against women. This course turns around the Istanbul Convention. It would seem that they do not take into account in that convention the context of armed conflict, that with the developments that we have around Istanbul Convention, there we can see lots of things that can be topical also for our subject matter here, the victim-centric approach and necessity to provide information sufficient for the victim to be in position to take informed decisions for themselves and for their own
Prevention
circumstances.
Prevention of stereotypes, prevention of re-victimization. We can say that victims during the war circumstances can be people of both genders, of all ages and the social groups, but the people who work with victims, they come not from some ideal world. They're just our own law enforcement people, and they also have some certain gender stereotypes. And again, here we see the same practice and methodology of professional interview. This is the only methodology. Moreover, there are different techniques and methodologies of holding professional interviews, taking into account the traumatized experience of the person, trauma-informed interviews. This is a two-way street, as a matter of fact, because those trauma-informed interviews, which take into account the trauma experience of the individuals, were formed by the military, and they came from the field of the armed conflict, from the sphere of armed conflict, but they are being applied in civilian life too, and they have been developed in this civilian life, and again, they can be applied for the context of armed conflict. I also would like to draw attention to one more thing, which unfortunately, because of the armed conflict, has lost its resonance and has lost its relevance, as it were, which is something which not should have happened. We have spoken about child-friendly justice for a long time. Why not use the same body of knowledge and expertise which were done within that concept? We have to adapt this concept to the context about which we're talking today. And for us, it is very important not to constrain ourselves within this topic of international criminal law. Unlike the International Criminal Court,
може використовувати
the
значно
Ukrainian system of justice can use a much broader range of instruments, not just the international humanitarian law and the international criminal law, but also other provisions of international conventions that Ukraine is a signatory to. And we have to consider this not as some kind of a problem that the majority of cases of CRSV will be dealt with by the Ukrainian bodies and not the international court bodies. We should view this as an additional opportunity, as an opportunity to work out more advanced techniques and practices of handling the survivors of sexual violence. We have to take into account the individual specific features of the survivors, be it a child or a woman or otherwise. Thank you very much for your presentations. They are really inspiring, they are practical, they are sound, and they give us a good foundation for our further work. There's one point that I'd like to respond to. The principle of the prohibition of generalization. We considered each of the cases as an individual one. There's no question about that. Thank you very much for this, and with your permission, I'd like to give the floor to Faride Rushidi, Director of the Kosovo Center for Rehabilitation of torture victims. I'd like to say a few words about Ms. Rushidi. We first met during the organization of Marathon Tirana Kyiv, when we discussed the unique Balkan experience of responding to CRSV. This is a concentrated expression of the work of the Kosovo Center of Rehabilitation of torture victims, and the methodology, the techniques that they use for reparations and compensations, and for providing the status of an injured party, which are necessary for medical support and assistance, for procuring medication and so on. All that is the result of effort of this center. And from the very first work of this center, Ms. Faride Rushidi worked as a doctor. She worked close to the border with Kosovo, and she dealt with the numerous patients. We are all very much inspired by your initiative. We are admiring the experience of your center. It's been 20 years and you still continue this work. New cases of CRSV are being recorded and you provide them with assistance. Thank you very much indeed for your work. And the floor is yours.
Thank you very much. It's my great dear organizer, dear estimate participants, human rights activists, UI experts. First of all, I would like to thank you for the invitation and opportunity to be part among you and share with a respected audience the many years of my work, as well as importance of inclusive approach, gender equality, and partnership to advance the right of war, rape, survivor, and justice. I just would like shortly to give some context of Kosovo. So following 98 and 99 war, Kosovo was largely destroyed. Besides the economic and social damages, the war left behind many human losses and thousands of other civilians who were physically and psychologically broken due to the experience of torture and trauma. Kosovo had also inherited 20,000 survivors of crime of sexual violence, a crime that was used as a weapon of the war, and unfortunately is used massively also in Ukraine those days, but also in other places when conflict happened. At the same time, atrocities were handled differently, so heroes were honored after the wartime, missing persons were publicly remembered, while war rape survivors were stigmatized and silenced. In such a context, prioritizing war rape survivors' needs was challenging due to the social norms, particularly in post-war years. While life after torture and rape was painful for most survivors, increasing gender inequality, violation of human rights to this group, leading to domestic violation, a lot of psychological consequences. They lost opportunity to be employed, they lost properties as well as dignity. I think I'm very glad, and I have to admire all of you that in a real time, as a state, you are opening the forum for conflict-related sexual violence in Ukraine. And I think you are in a unique position to avoid all mistakes that we did in our country due to the delay on recognizing such a crime by legislative perspective, but as well as due to the stigma and prejudice that existing in our community related to this crime. In responding to this, we tried in 1999 and we achieved to found Kosovo Rehabilitation Center for Torture Victims, a pioneer and unique interdisciplinary organization which was treating torture victims, but with a specific focus war rape survivors through rehabilitation service, legal assistance, medical treatment, advocacy for policy change, but as well as we supported the state institution to draft secondary legislation, protocols, guidelines in order to advance the right of conflict-related sexual violence. 20 years after, Kosovo Rehabilitation Center for Torture Victims has succeeded to provide holistic care to more than 10,000 traumatic survivors and their family members who were impacted by war. Among those, there are around 1,000 of survived sexual violence who are well documented and who are going under the treatment. I heard in the previous panel that you mentioned you have also men and boys who are impacted from sexual violence. And I have to say that in our organization, we already have 10% of the beneficial men who are coming regularly for session, although the stigma, self-stigma about this crime to this group is quite high, but we wish to integrate them in our treatment program. So as you see, compared to your country, to Ukraine, it took us 15 years to advocate continuously in order to make legislative amendments and to ensure legal reparation for conflict-related sexual violence survivors. So in March 2040, from 1999, finally the survivor sexual violence were included in our legislation under the law, which is treating all war categories. This was followed up with the development of secondary mechanism to ensure the implementation of the law where again, our organization under my leadership played a leading role, and it took us another 4 years to work with the institution in order to implement the law. So in 2018, finally, the State Commission for Recognition of the Status of the Survivor of Sexual Violence was established. In this process, we drafted to the draft instrument for recognizing the status of the victim of war-related sexual violence. And I would just like it to share, if it's possible, here in a Zoom. So it's a document. I would just need to remove the blur. So it's a document which it served to the Kosovo Government Commission, the way how they verify and recognize the status of the victim. I have to say that also for you guys who are present in this room, it will be quite problematic to find a way what kind of documents or facts and figures you need to consider for the survivor sexual violence. Well, comparing our situation that this process it started 20 years later, I think again you have a different situation. You are in a real time. Perhaps with the documentation you start already to advance, as I heard, because it's not so easy. I mean, the crime in itself, it's so horrifying crime, and it is very hard to be documented, first of all. It is very hard for survivors to share the stories. So having this kind of information in our country that in the beginning we dealt only with the treatment without considering documentation, I think we had to pay the cost later on. So having proper documentation on place, comprehensive one based on do not harm principle, will facilitate a lot of the work in the future for the conflict-related sexual violence. So since 2018, in KRCT, we are supporting all of the survivors in the stage of application process. What we do in the application process, we support them to compile a format of application when they have to describe in very detailed manner the narratives of the war. They have to, if they have any kind of medical, legal, or psychological document, we have also to prepare those and all of them to submit to the State Commission for verification and recognition. This is an important step for the survivors in our community, because right now there are around 1,600 survivors who already are able to benefit personal pension from a state. And I can say that a lot of those women and men, because not only women applied, but also 10% of men, I think after gaining such a status from a state and having some support, life changed in their family and in community as well. Another advocacy action which I would like to bring it to you, we reached again after 24 years of working with survivors, is that this year we for the first time officially we recognized by the support of the Office of the President of Kosovo, April 14 as a Memorial Day for survivors sexual violence during the war in Kosovo. And while we are in this forum, I strongly recommend that you have to think also for one official day, which will serve as a Memorial Day for survivors sexual violence also in Ukraine. All this extensive work and impact would not be possible without having a partnership with organizations, institutions, and individuals of goodwill. Our survivor-centric approach is followed by local, regional, and international networks who KRCT cooperate with, and numerous training courses that the center's team received in order to make sure that this proper type of help was being offered to the survivors. Well, working with the survivors, I think it's quite challenging, it's quite demanding. So whenever the organization decides to have in its mission such a part of the work, they need to be trained well, they need to have protocols in place, they need to have manuals, they need to ensure the confidentiality of the survivors. So there are certain steps and development of the organization that needs to be taken before you start to enter in the field. Another, beside that, we work as an organization quite a lot on advocacy, awareness raising, as well as in mobilizing efforts of multi-stakeholders. And through that, we reach to establish a national network as a Be My Voice platform, which brings together local NGO working in advancing the causes of our rape survivor. I think also in Ukraine, it's so important to establish a network of the organization who are working with survivor sexual violence in order to support each other, in order not just to support, but also share information, share capacities. So it is so important to have much more articulated voice in the future, to be a kind of national network when you could share, strategize, support each other, but also advance the causes of survivor sexual violence. As an organization, also we have a regional joint project with partner organization in Bosnia and Herzegovina and Serbia in amplifying the voice of war rape survivors, while our experience has been shared in different international initiatives and networks such as Global SEMA Network, Preventing Sexual Violence in Conflict Initiative. Lately, with UEA expert, we reached to have MOUs and establish official cooperation and partnership in the field of exchange practice of rehabilitation, reparation, and justice. Kosovo experience was shared also with the Yazidi community, and survivors of Kosovo are traveling and sharing practice worldwide, as well as we shared our practice with Guinea, because they start administrative reparation work currently. But we are also in a close cooperation with Mukwege Foundation, and we shared our practice also with DRC. In the morning session, I was able to hear a lot of information about justice, how we have to approach justice, challenges, international justice, national justice. And I have to say that justice is quite challenging to be ensured for this group. To ensure justice and accountability, the justice system need to adapt trauma-informed approach in context of conflict-related sexual violence, refer to the way of providing care and support that recognize the impact of trauma survivors and integrate this understanding in all aspects of service delivery as well. Why I am bringing that? Because certain survivors are in different recovery stage. And depends on the recovery stage, the trauma mosaic could be shared in different ways. Sometimes during the process of justice or witnessing process, they could be re-traumatized due to the being unprepared mentally and psychologically and emotionally. They are unable to bring the mosaic of trauma. And due to that, sometimes they fail also to bring the whole narratives of the war. In our country, because I heard a lot about the international justice, I have to say that Kosovo was led from UN administration till 2008, 7-8, and war crime unit were under the UN administration. Then after UN left, we had an EU mission, EULEX we call it, EU mission rule of law. So till 2080, again, EU mission was dealing, it was a hybrid court, it was dealing with war crime cases. I have to say that in both international war crime units, sensitivity towards the survivor sexual violence was missing. As a result, none of the case who reported from 99 till today, because just recently we have a first case, they didn't receive justice, especially when we had those international hybrid courts in Kosovo. The way as they approached to the survivors, it was completely insensitive way, because in our society still survivors are suffering from stigma and prejudice in their community. Some of them still didn't share the story with their family. And the way as this international body approached to the community, exposing them, they harm more than they support them. And more than that, sometimes when survivors were investigated for hours and hours without considering a recovery stage, mental stage, they become a suicidal case. And in that period of time, they asked organization to jump on board and provide some support to the survivor. But it was very late, because survivors already were re-traumatized. They didn't want it anymore to enter in the process. They didn't have it anymore inner energy and capacity and resource to continue. So as a result, none of them received the justice. There were two cases historically went through the UNMIC and EULEX. It is known case of Marte Tunaj. She passed away, unfortunately, and she spoke publicly about case. Her case was dismissed in a Supreme Court, while another case which is known for Kosovo society is Vasvija Goodman case. Also, this case failed in a Supreme Court. Currently, or just recently, I have to say that we had a first case who was finally get the epilogue in the Supreme Court. It's a Zoran Vukotic case, who is in prison now 13 years. So from 99 till now, there is only one case who finished 3 levels of justice, and we could say that justice is served for one survivor. This lady, who is our beneficiaries, we are supporting her with all means, psychological, medical, legal means. She already shared her testimony in UNMIC administration in 2003 or 4 in very early stage. Nothing happened. Again, she tried with EU mission. Unfortunately, nothing happened. When she approached in our organization, she was as a very, very hard psychological case. The lady lost 2 twins children. She was pregnant when she was raped. She never ever, she was under interview, investigation, testifying. She never ever received any feedback from those international courts. And she came in our organization just being recognized as organization dealing or rehabilitating survivors of sexual violence. She approached to us to be rehabilitated, and with the idea that if she would be able in the future to enroll again in the process of justice. It was quite a challenging case, but after we worked with her around 2 years, and with a good cooperation with a state institution, she reached to testify in a basic court. Her case was in appeal court. She returned again in a basic court, then again in an appeal court. And finally, those days, we have a final decision of a Supreme Court. What I would like to share with you from a Kosovo perspective, you know, in one dimension, you have to work with a survivor sexual violence, to work with their family. Another dimension of intervention is to work with the institution who will be able to work with the survivors. And in order, we reached to have to develop a second protocol, which is protocol on identification of protocol on identification, investigation, and treatment of sexual violence case during the war in Kosovo. This protocol, we work together with many state actors. It's here with many state actors. It's based on international protocol of PSVI on documentation investigation. And we reach to bring all actors surrounding survivors and defining the roles and responsibilities of those actors from police custody, prosecutor office, logistic perspective, judges, NGOs, legal support. So here is the schema. Sorry, I cannot share it more than that, but I am willing to share in different circumstances. So we try to prepare a protocol when we ensured the role and responsibility of all supporters during the prosecutor phase. We reached even to establish the open question, what kind of question can be addressed from a Kosovo Police War Unit and State Prosecutor Office. We reached to ensure the need of psychological support during the investigation or testimony phase. And in that perspective, we reached to have MOU with the State Prosecutor Office. So there are 4 organizations in Kosovo who are working with survivors of sexual violence. We are, as a lead organization, beside rehabilitation, also in the process of drafting those kind of state documents. And through this protocol, we have already MOU with the State Prosecutor Office in Kosovo. And instead of sending survivors from our organization to the police custody or to the office of a state prosecutor, whenever the survivors are ready psychologically, we invite State Prosecutor Office, Kosovo Police for war crime, and the first contact and interview and testimony is done under the organization facilities. Why this is important? Because we have to consider that survivors are traumatized population. If you send them in a place when they don't know, or it's a police custody, it triggers to them trauma. So being in an organization when they come freely to get the service and they have a lot of trust, we already create a condition that they feel comfort and safe during the interview. Then having a psychologist present during the session, it's a safeguard we ensured by this protocol. It is allowing survivors, whenever she is triggered, whenever she is going deeper in her trauma or explaining what's happened, all mosaic of trauma, psychologist is entitled to quit the session if the survivor has any kind of flashback or triggered or dissociated or any kind of element of trauma raising the surface. And in that way, besides that we support survivors to be able to share her story and narratives, we support the justice, because if the interview is done without presence of psychologists, without preparation of the survivor, usually those cases are failing in the process because they are unable, due to their mental health status, due to the trauma, unprepared trauma, untreated trauma, they cannot share their story. Sometimes they just withdraw from a process, they don't want to continue, they feel re-traumatized, and they cannot follow other steps in the justice. So this is one part of what we do. Second part is to support the survivors in the court process. What we do in that perspective? We are with the survivors together whenever she have to testify in the court. We support her, we prepare her. We have to prepare also court bodies, as well as we have to support mentally survivor till the decision is taken. Because as you heard earlier, the case of Zoran Vukotic went 2 times in the basic court, in an appeal court, so it was a very long case. And during whole this period of time, around 2.5 years, survivors have to be continuously under treatment because they are in anxiety. They don't know what is happening, if they will fail to receive justice or not. If they will fail, they fail also in a family and a community, and it's big burden for them. So in order to have success case in a justice, you need
Пані
to...
Люш, thank you very much. Ми вам щиро вдячні за ваш виступ.
I would like to thank you for your presentation. It is a great pleasure for us to cooperate with you. We are implementing the memorandum, but we can continue this conversation because we were supposed to finish at 1600, and we have still 2 presenters to go.
Thank you.
Valentina Lukanek-Shachova, senior lecturer of the Academy of Internal Affairs. It is very important to talk about people who represent specific positions. And for Valentina, war started not in February 2022, but back in 2014. So in continuation, as a follow-up to Farideh's presentation, Valentina will discuss our international protocol for investigation of the CRSV crimes for Ukrainians. It was started in 2014. That was a war for civilization, of civilization against Ukrainians, against our identity. The Russian Federation waged it back then. In the civilized world, this issue is still topical, and for 9 years, we have been opposing this active Russian aggression against Ukraine, and this issue, of course, excited not just the European region, but all the world. And I think that our young attended so the round or the conference, I suppose, watched the international news regularly, and we can see that all the civilized countries start their day with the news from Ukraine, on Ukraine, and the contemplation and discussions of what they can do to help Ukraine. Without investigation of such crimes, we cannot do. This is an integral part, and every single panel opens up another array of problems, and we had the Ministry of Defense speaking through the representative. Ukraine is unique because we are training, we are studying, we're developing the academic studies, and we are fighting the Russian Federation's aggression against Ukraine, and also we are improving the legislation for this fight and for the future possibility to protect our territorial interests and our sovereignty, and thinking about how we should do it for the victims, for the survivors, for the sufferers, for the injured persons, whatever we call them, to get the due in reparations. And the international protocol for documenting the investigation of CRSV has been finalized. It was actually finalized in 2014. It's not a binding document, it's not an international covenant or convention of customary law matter. These are guiding principles. These are guidelines, we can call these documents, for experts of the national bodies, governmental bodies, law enforcement, medical care, and NGOs, international bodies and organizations engaged in documenting, investigating in the broadest sense imaginable. And in 2014, that protocol was first presented for the first reason and adopted, but by 2014, as you imagine, we can see best practices of the International Rwandan Tribunal, former Yugoslavia, practice of ICC, a case law of ICC that is being now enriched with the new cases. For the terminology, the protocol uses victim and survivor, the two terms. As Faraday discussed it, I noticed that she was practically using survivor. But the international protocol as a kind of symbiosis, the national and international law suggests both terms. And if we discuss the international, it's victim, because that's the term used in the sources. Perhaps I am not informed enough, but Article 9 of the Constitution of Ukraine, the international covenants become part of the international legislation. We are not amending any international agreements. We can make our own cautions, issue cautions, but there are things necessary for the criminal procedure. but we should not use such reservations because the language of the protocol is clear. What is very important, there is this memory pad that we can use it like that for the victims or survivors to get reparations, and how we can use it as a cribber for confidentiality principles. That makes it binding for the law enforcement officers and medical personnel dealing with the victims. You can use this protocol especially when it comes to risking their lives and security of their families. They're providing assistance to such persons in the temporarily occupied territories, because providing assistance in the territory under Ukraine's jurisdiction is much safer than to provide assistance in occupied Mariupol. Just as an example, I use this town, and for a person who suffered from sexual violence, if we can call them soldiers of the Russian Federation, they don't deserve the name. And what should medical doctors do, personnel do? Provide medical assistance, then apply to law enforcement. What kind of law enforcement in the occupied territories? The occupying authority in the occupied territory. Well, I don't think this is safe for the doctor and for the victim, for that matter, and people, citizens of Ukraine who stay in temporarily occupied territories. They can approach the ombudsperson, and it is such a sensitive topic whether they have enough courage to inform the ombudsperson, and that's why Ukraine is not unique when such evidence might resurface after a long time post-conflict. And for the victims, that the protocol interprets as victims of sexual violence, who can qualify? I think women and children as the most vulnerable categories, of course, but we focus our attention on all the cohorts of both principal genders, men and women. According to the statistics, more than 80% of the survivors of sexual violence are men of different age and persons older than 50 or 60. Well, much older in some cases, but there is no typical profile of a victim. Anybody can fall victim. People with disabilities, LGBTQ community, and the perpetrators sort of reform them because they disapprove of their lifestyles. And this is the occupying force, the occupying authority, but they think that they can also reform, in quotation marks, reform the corrupt persons. I would like to say that the protocol itself also identifies the principles for compensation of damage done to such survivors in conflict. One of the principles is proper judicial remedy and our defense and compensation. What is meant by that? First, restitution, if possible, restoring that survivor to the original status, and then compensation. When we hear this term compensation, first of all, we associate this term with financial rewards, but there is a whole set of cases when pecuniary compensation is not considered sufficient. There's also physical and mental injury, moral damage, lost opportunities for the persons who were subjected to such violence. Rehabilitation should be added by all means for the survivors in conflict, and also satisfaction in terms of justice, whether they are satisfied. We've discussed it, whether they feel that they have been justly treated after the conviction. And one last big task, not just for the state documenting such crimes, the CSV, but a safeguard against recurrence of this, and guarantee that this will never be repeated. The war conflict, this is for all the humankind and civilized development of the nations in the future. I was very pleased to hear from Faraday. They have protocols they implement that based on the international protocols. They created their own, and they're already using that with the victims. And this is great because this is more than 300 pages with recommendations and all, so that the states at the level of their national legislation or their national communication use and implement such provisions. Please familiarize yourselves with this protocol for dissemination of information when you in your classes, at your workshops, you do that. Unfortunately, it's your destiny to live and through this war, to experience it, and youth is all for entertainment and fun, but you're suffering from this armed conflict. Of course, we shall overcome, and I think you agree with me. Glory be to Ukraine. Well, thank you very much, Valentina. Thank you for your advice, for your presentation. And now I would like to turn the floor to Natalia Kaninska, PhD, professor of the chair of international law of Taras Shevchenko University. We've been friends for a long time. She is a distinguished academic in human rights. An academic practitioner and international mechanisms and prevention and response to CSV, and we are all concerned with that. So international experience and observe the timelines, please. Thank you for the invitation, for the opportunity to join such a important discussion. I would like to be very concise because I think see how tired and exhausted people are. Let me focus on the principal messages that we should all take into account as academics, and you as future academics will keep learning, keep studying, because to stay posted to be aware of the developments, we have to experience this exchange of expertise. We exchange knowledge and best practices. I've known our moderator for about 25 years, and that was when I graduated from Taras Shevchenko University. It was quarter of a century ago. My daughter studied in the same university as a first year students, a secular historian, Valentina. We worked for almost 10 years together. Once, it's not all coincidence on this slide. And Valentina, I am really concerned with the same thing. I have a fellow feeling, but I also have a belief in a faith in you. Have faith in you, and so that you borrow the necessary knowledge that you need, the Ukrainian state, and without any exaggeration, all the international community, because things happening in Ukraine, not just with this war and your integration process, that you probably are well aware of what's going on. And we have special conditions, not like other EU candidates before us, candidates for the EU, but we have certain peculiarities, let's say, siding sometimes located at strategic points, influencing the learning process, the environment, and the system of international relations. I am not going to lecture you, and regardless of the fact that I am a member of faculty at one of the universities, but I am also lucky. I now judge this competition of student academic work arranged by Lynn Kuchma Charitable Foundation. So the topic is related to the events which are topical, and as of now, and we are going to summarize that next week to give awards. And this is damage caused by the Russian aggression against Ukraine. And our students, postgraduates from other education institutions now reside in different states. They offer graduates, postgraduates, students, they offer some fresher ideas, sometimes specific proposals and things that we read about in certain recommendations. I am not going to underestimate contribution from specific experts and or entities, and also case law coming from the international forum. And this is also very topical. So while listening to our colleagues, I was looking up, I looked up some decisions of the international courts. You as students and postgraduate students have to stay put, because case law of ICC applying the Rome Statute is not that easy to get through. Congo, Central African Republic, and Rwanda. Well, there were certain crimes that we do not pay attention to, like forced pregnancy and sexual slavery. And in specific court decisions, we can find that. And it is not the most important matter of interest, but the procedure for liability and conviction. In ICC, there's this court chamber and appellate chamber, and there's this practice when big work is applied by international experts and law enforcement, all sorts of forensic experts. But then there are appeals sometimes upheld against our survivors and the sexual violence related to the conflict. I'm not diving too deeply into that. This is your field for the future. It's for you to participate in such procedures in recovery of Ukraine and compensation for specific victims of sexual violence, because it's you, who else? Right? And I would like to draw attention. Sorry. And there are some opportunities for you, for your professional development. For a long time, I cooperated with UN Women, and there's this opportunity for young academics, more experienced academics to get internship at different centers. I was lucky to get internship in Sweden, Gender Competency Center, founded by NATO and UN Women together. There are short and long-term internship programs where you can familiarize yourselves with different international practices and international institutional mechanisms, control and coordination mechanisms, and you have experts from different countries of the world and also survivors who mastered courage, and they can discuss their experience, and representatives of international fora. So here is a field of activity for you, professional development, acquiring skills, and you should not shy away from that. You are intelligent, you have great prospects and opportunities. So in you, I trust. Now, coming back to our reality and specifically the aspects of my topic, we have lots of comments on the lack of efficiency of the international mechanism, starting with the UN and inclusive of certain UN family organizations, and regardless of the fact that we have special envoy of Secretary General of the UN, and there are many institutions, and also with IOM, UNICEF, and Committee Against Torture, not just under the UN, Council of Europe, the EU. And we have to mention here that we still have on the previous panels, we were talking about ECHR and their jurisprudence, and also in the part of such crimes having to do with survivors in Ukraine. So I promise to be brief. Let me just say that all the existing international mechanisms should be focused on specific vectors, and they should be most topical. The most topical ones are the international instruments which are effective, not dead, not declaratory, but providing guaranteed positive results and promise. And they are dynamic, they are developing, and they are not frozen or petrified, but this is for support of survivors in conflicts, and providing legal aid in criminal and other procedures, exchange of experience. Yes, and for the future, another aspect is this formal cooperation for proper enforcement of international court decisions. This is one of the gaps. At the same time, to finish on an optimistic note, this brief account. Ukraine is at work, Ukrainians are at work regardless, and the younger generation is the best because even studying abroad, they prove that they the best at the top of the ratings, and also very active in civic active movements, NGOs. I think that's the way to go. We believe in you, we trust in you, we believe, and international community and should not sit on their hands, and they are not. Thank God for that. Thank you very much, dear colleagues. On your behalf, I would like to thank our speakers and say that all our remarks and all our contributions today will be put together for a follow-up collection of works. We have more than 50. We have discussions, so we have certain exchange of opinions, and as a result of that, we are arriving at some common understanding and shared results. So, according to our agenda, I would like to turn the floor to Sergey.
Ви не питаєте, чи є питання, да?
Ми вирішили дотримуватись регламенту.
Добре. Я думаю, що сьогоднішня конференція окреслила проблеми, які в принципі ми розуміли і які були, але я б виділила для себе і структурувала їх по певним напрямкам. Ну, по-перше, почнемо з цивільно-правового напрямку, тому що він є найбільш, як на мене, не скажу, що легкий, а в перспективі найближчий, найбільш реалізований може бути. Починаючи від різних форм, які можуть бути, це можуть бути, ну, як для мене, думаю, що найбільш оптимальний є колективні позови, де доказова база буде ґрунтуватися, скажімо, лише на певних фактах, які є встановлені, які сприймаються національним законодавством, міжнародним законодавством, і це те, що потерпілі в певні наближені строки можуть отримати від, скажімо, кривдників, да? Чи то кривдників держави, чи когось іншого. Другий аспект – це, власне, кримінально-правовий національного законодавства. І тут ми з вами говорили про те, що є дуже багато питань, які треба вирішити на рівні національного законодавства, починаючи від імплементації відповідних норм міжнародних, саме в законодавство матеріальне, ну, кримінальне законодавство про кримінальну відповідальність, і відповідно подивитися, які в нас в
Then we have to take a look at what can be borrowed at the level of legislative initiatives. But I don't have even cautious optimism that the legislature in Ukraine understands all the urgency of these issues, because it's very difficult to reach out to them, even at the level of general understanding, just at the level of overall comprehension. At the same time, there's a support component, which is not just about the implementation of certain norms about criminal responsibility, but there is also a big loophole in the procedural legislation, which should be addressed at the national level. It can be singled out and considered
Кримінального кодексу я
separately. I've referenced the experience concerning the criminal code, and I said that this is the labor of Sisyphus. Even if we draft a genius criminal code, but if we put in place just this genius criminal code and fail to draft an equally good procedural code and all other relevant pieces of legislation, including jurisdiction, law enforcement, and so on, if we fail to do all the rest, all this work will be in vain, and we will have to make an general overhaul of all this, because our approach should be comprehensive. The third aspect is an international one. This is as regards Ukraine's representation at different international institutions and court institutions included. Having said that, during the first panel and during the second panel likewise, I came to understand that we observe this phenomenon not just in Ukraine, but in the international community and at the global level likewise. The humankind has developed a bunch of wonderful conventions, international laws, bilateral, multilateral conventions and agreements, but all of them are drafted on the basis of experience of previous aggressions and in the environment of peace. And when the world confronted the situation whereby a permanent member of the UN Security Council is the aggressor, the world doesn't know what to do. Everything comes to a standstill, and all we keep hearing is that the UN needs to be reformed. I think that the UN is in for the same fate as the League of Nations had in the past, because it has run its course and exhausted the mandate which was originally provided to it. We don't see that they are ready for real reform, and that they are ready to meet the modern challenges. I believe that today's conference, which we've dedicated to one of the most relevant problems, is not sufficient, because one conference will not exhaust all the problems that needs to be addressed. So I believe that we will continue this practice, holding roundtable discussions or in other formats, but the requirement for this is here. I'm very thankful to all the speakers, all the panelists, to our international experts, and obviously we are thankful to UA Expert in helping us to organize this event. Thank you, Angel. Dear colleagues, dear ladies and gentlemen, we summarize the 6 hours of work of today's events. We wanted to run a 2-day event, but then we reconsidered and decided that within 1 day we will be able to involve not just all the relevant experts, but also to create a unique content, which we also have in a video format, and which will be used by Anton Koronevich at the international level, for our partners in Kosovo, in the Balkans, and in the UK, and the words of Pamela Patton, the special representative of the UN, who said that Ukraine has really made a progress in responding to sexual violence crimes at a high legal level. Well, those words speak for themselves. And I'm gratified to say that we have very good cooperation with the Department of Criminal Law, and of the institute of our university, which is really a driving engine in this field. It's a pleasure to cooperate with them. And today we can say that we are launching a new kind of cooperation. And this is just the beginning of our grand plans for the future. And I'm sure that our motto, acting for survivors, again, speaks for itself, because we have just scratched the surface. There's a huge work ahead. Let's march forward. Glory to Ukraine, and see you in the future.